Mr. James H. Lucas to Ms. Nanette Edwards, who is the Executive Director of the Office of Regulatory Staff. Have you ever seen this document before?
No, I don't recall I have.
Right. Have you been told in the course of your engagement in this matter by anybody at ORS that there was a letter from the Speaker of the House which discussed ORS's position in this case and its position relative to the experimental rate that was enacted by House Bill 4375?
I read a news report about the letter, but I don't recall ever seeing the letter previously.
Okay. Well, let me just ask you a couple of questions about this, and what I want to do is ask you some questions about whether this letter has in any way impacted your opinions in this matter. You see, sir...
excuse me, I don't have a copy of the letter.
We will remedy that immediately.
Thank you.
You see, Mr. Collin, in the third paragraph there, where Speaker Lucas says the General Assembly spoke clearly by overwhelmingly voting to enact an experimental rate. Both the House and the Senate agreed that while a complete abolition of any nuclear premium is ideal, it is also likely impossible. Did I read that correctly?
Yes. Just let me make sure that I understand the context here. The nuclear premium is a reference, if I understand it correctly, and I know I don't get to ask questions, but this is the first time I've seen the letter. But the nuclear premium, I think what the reference is to revised rates. Is that a correct understanding from your perspective?
I'll give you two today just because you've been so...
Well, thank you.
So compliant. Yes, it does refer to the revised rates.
Okay. Okay.
And then at the end of the first page, the last paragraph, did Speaker Lucas say that that rate was subsequently challenged in federal court and was found to be constitutionally appropriate? With the constitutional appropriateness already determined, it would seem wise to fully consider the experimental rate already adopted by the body vested with the rate-making authority under the state constitution as a potential remedy. Did I read that correctly?
Yeah.
And then turning over to page 2, did Speaker Lucas refer to the fact that Dominion has now filed an alternative relief proposal with the Commission that includes vastly improved short-term rate credits, long-term rate relief for the ratepayer, meeting several key positions that ORS included in its pre-filed testimony, including yours, that Dominion's agreement with ORS to significantly reduce the post-abandonment cost to the level demanded by ORS, lower the rate of return, and decrease the cost of debt, and that these concessions by Dominion are undoubtedly victories for ORS and, most importantly, the ratepayer. Do you agree with those statements?
I do not. I agree that certain aspects of the alternative customer benefits plan do, in fact, meet the ORS optimal plan. However, the net effect is to increase the net present value cost to the customer even from the customer benefits plan. So in our assessment, the applicants have taken a plan that is not or that results in an excessive rate to customers and increased the recovery from customers compared to the customer benefits plan. I do not agree that this is a victory for the ratepayer. I mean, you can meet certain components of the plan, which Dominion has, but it's taken away certain other components. And the net effect of all of that is to actually increase the cost to customers on a net present value basis. So take an already bad plan and making it worse, basically.
I promise you we're going to come to that subject of your critique of Plan B in a moment. But before we do that, let's finish with the letter. Does Speaker Lucas go on to say that I, in particular, appreciate the desire to pursue the lowest possible rate, But jumping down, I have, however, come to believe, and the ORS pre-filed testimony concedes, that the rate we both desire is unattainable. Continuing, it would be the worst possible case for ORS to convince the PSC to set an unobtainable rate or for SCANA to successfully challenge that rate in court. Concluding, I hope that you will consider fully the long-term implications of asking for what we know we cannot obtain, and that you and ORS will fully consider the wisdom of the experimental rate already passed and tested. And my question to you, Mr. Collin, is, has ORS, in your view, fully considered the wisdom of the experimental rate already passed and tested?
Well, the best way that I think I can answer that is right now, with the experimental rate in effect, the recovery of or on the N&D costs is about $78 million. Under the ORS plan, that rises to $86 million. So, I'm not sure if Mr. Lucas fully understands the complexity of the plans, but the short answer to this is that the ORS plan provides for the N&D cost greater recovery, slightly greater recovery than under the experimental rates. The tax savings rider, the one-time tax savings refund, that's all consistent, even though the dollar amounts are a little bit different between Dominion and the ORS. And then the only remaining difference is the merger savings rider. But with respect to the N&D costs, we're actually providing a greater recovery, $86 million, compared to under the experimental rate, which is $78 million.
And Mr. Collin, just to follow up on that, you said that this morning as well. You basically suggesting, well, SCANA, Dominion, they're better off under my proposal than they are today. And I know, again, you're talking about revenue requirements. A lot of us are talking about the actual customer rates because that's important. Just going back to my table from before, you don't disagree with me mathematically, sir, that the current rate under H4375 is $125.34, and the ORS plan is $9 less than that, right? Mathematically, it's $9 less. It's $116.77, right?
That's true on your chart there. And again, I don't know the veracity, the correctness of those numbers, but I did point out this morning that I don't think you have an apples-to-apples comparison on your chart, despite your assurances, but I don't believe it is an apple-to-apples comparison.
And we'll let the Dominion witnesses address that. But just to close it out on Speaker Lucas's letter, he refers to SCANA's potential to successfully challenge the ORS rate in court. We've talked a lot about risks associated with the ORS optimal plan and certainty associated with the Dominion plan. Would you agree with me, and I know you're not a lawyer, sir, but would you agree with me that another risk which exists here is, in fact, if this commission adopts the ORS optimal plan, that will be challenged in court? In fact, it's almost a certainty, isn't it?
I would anticipate there could be a court challenge over different aspects of the optimal plan, but that's true in any rate proceeding.
And I take it it's ORS's position, like the risk of Dominion walking away, like the risk of bankruptcy, ORS believes that's worth the risk. The risk of an appeal here is worth it, and the commission should adopt the ORS optimal.
Well, I don't think I would characterize it that way. I think I would simply say that there is always risk when the commission makes a determination of rates that the utility will appeal it, whether it's the rate of return or a disallowance of a cost or the quantification of a cost.
Obviously, the utility wouldn't appeal the commission adopting Plan A or Plan B here, right, because they proposed it.
Well, I would assume not.
So,
unless there's some condition that they would find onerous as well.
So, Mr. Chairman, may I ask that this document be admitted to the evidentiary record?
It will be admitted, and it's into the record, and it's exhibit number 53.
Mr. Chairman. Now, Mr. Ziegler spent a lot of time with you this morning talking about bankruptcy, and we talked about it yesterday, so I'm not going to spend much time on that because I know we want to move things along. I just have one point that I wanted to clarify with you. There's no question in virtually every bankruptcy of a corporate entity like SCANA, the equity holders, the shareholders end up getting wiped out, right?
Frequently that is the case, but then the debt holders become the equity holders under a typical bankruptcy
Fair enough.
proceeding.
And,
But there's a sharing, of the restructuring pain in the sense that the debt holders may get less than $1 on the dollar. But in any event, it is a way to resolve everything, and from a customer perspective, it could be beneficial. I'm not advocating it, once again.
Fair enough. You're not advocating it. We're just talking about the risks that it would occur and what the consequences of that occurring would be. So you're aware that most of the equity holders, the shareholders of SCANA, are institutional investors, right?
That's typical with utility holding companies. I have not investigated SCANA specifically, but that is typical.
There's pension funds, retiree funds, that sort of thing, that invest in utility stocks for the dividends and otherwise, right?
There's a variety of investors, including institutional investors.
And shareholders would also include the employees of SCANA and retirees of SCANA.
I'm sure there are some that hold stock, yes.
And others across the state of South Carolina that have bought SCANA stock over the years.
Yes, that's correct.
And those folks would, in all likelihood, get wiped out.
I don't think that's necessarily true, but I think what would happen, and as I discussed with Mr. Ziegler this morning, is that the stock traded at a price after the termination of the project in late 2017. Then when Dominion announced the merger agreement, the stock price went up. And I would imagine if Dominion walks away, absent another suitor in the immediate wings, it may go back down. But then if another suitor steps up the plate, it could go back up. All of these actions affect the stock price. But I don't see a legitimate scenario where the existing shareholders of SCANA are wiped out. I think that's inaccurate.
Talking about in a bankruptcy proceeding, not this hypothetical. Maybe someone else moved in and.
Well, the bankruptcy itself, excuse me, I didn't mean to talk over you, but a bankruptcy itself is a highly hypothetical and I think highly unlikely scenario.
All right, sir. But if it occurred, you would agree with me a bankruptcy of this magnitude could potentially take years to resolve and cost hundreds of millions of dollars in legal fees and otherwise.
There is a time associated with a bankruptcy proceeding, and there are consequences of that, both good and bad.
You just discussed, and Mr. Ziegler discussed, the debt holders' position who have mortgage liens in this case. That debt is not going to get wiped out in a bankruptcy, right? We're not going to wipe away $4.7 billion of investment in a bankruptcy, right?
Well, again, this is a very, very hypothetical, out on the edge of the cliff type of hypothetical scenario. This is not a realistic scenario. None of your witnesses are asserting that. None of them.
So
and wait, I wasn't finished.
Pardon me, I didn't mean to interrupt.
Okay. And so, to make the argument that under this highly unlikely, very hypothetical scenario that the debt holders don't go away through bankruptcy, I mean, there are any number of outcomes in a bankruptcy if there were to be one, including a prepackaged where there was agreement with the creditors. There could be a conversion of some of the debt into equity. There could be a reduction in the debt outstanding. I mean, these are all different potential outcomes in a bankruptcy proceeding. We don't know sitting here today what the outcome would be in this very hypothetical, very unlikely scenario.
Quite a bit of uncertainty, right?
I would agree with that.
And just for the record, and then I'll move on, I want to make sure I've got ORS's position clear. ORS is not saying in this case, bankruptcy sounds like a terrible alternative and we ought to figure out a result here that avoids that prospect. You said this morning bankruptcy could be beneficial. Is that ORS's position in this case?
The position of ORS is that there is not a bankruptcy on the horizon, period. And the ORS plan is sustainable. And in fact, it produces just and reasonable rates. It is balanced and it provides a guaranteed recovery and a guaranteed rate of return on the N&D costs. I don't see any likely scenario where there would be a bankruptcy.
Let's move on, Mr. Collin, to your critique of the Dominion merger benefits plan or plans. And to be clear, Plan A, which was the one with the upfront refunds and then the buy down over time, which we discussed at length this morning, that is not a plan, the original customer benefits plan that ORS supports, right?
That's correct.
And you spoke a little bit about this morning, saying that you think the 1.3 or OS characterizes the 1.3 billion in upfront refunds as a loan because you got to, pay it, in your view, pay it back over time, right?
Well, not only pay it back, but pay it back with interest. And so that adds basically another $900 million to the $1.1 billion over the 20-year recovery period.
So would you agree with my characterization, Mr. Collin, that Plan A compared to Plan B sort of front loads this $1.3 billion, and then you have a smaller amount that is serving as a rate credit over time, the $570?
Yes.
And you understand this is still Dominion's preferred outcome in this case. You've read the testimony.
I have.
Now, with Plan B, the one that drills down on the permanent rate relief, gets the permanent rate below $127. By contrast, would you agree with me that relief, that $1.9 billion that's coming off of Dominion's balance sheet, is really back-end loaded? There's no upfront refund, and it's spread out over time.
I'm not sure I agree with it coming off Dominion's balance sheet.
We talked about that.
I'm not really sure what you mean by that, but in
any
event, it is true that the refund of the Toshiba proceeds is over the 20-year period.
And then getting specific about your criticisms of this plan, I'm going to put your supplemental surrebuttal testimony, which is a mouthful, of October 29, 2018, page 2, up on the screen. In summarizing that supplemental surrebuttal testimony, Mr. Collin, did you say that you recommend the Commission reject the Plan B, the alternative CBP, because it will cost customers approximately $140 million more than the merger CBP Plan A and $420 million more than the ORS optimal plan on a net present value basis? Did I read that correctly?
Not quite, but the substance is essentially correct, that it is more expensive than the original Dominion customer benefit plan on a net present value basis, and it is increases the differential between the ORS plan and the alternative customer benefit.
And again, under that Plan B, you haven't verified the numbers, but this is the plan that reduces the N&D component, as I'm showing here on the table, to $4.50.
That's what it shows on that table, but again, I don't have any way to verify that.
By the way, do you know, Mr. Collin, when the last time the N&D component of rates for SCEGS customers was at $4.53 or lower?
I don't know, because I haven't translated any of my quantifications to dollars per customer.
All right. And maybe we'll ask Mr. Seaman Wynn that question, but would you accept, subject to check, that it was back in 2010, that this would roll rates back to the 2010 levels?
I have no idea.
We'll ask Mr. Seaman Wynn. The NPV analysis that you did, so we can sort of take it down to the layman's level, outside the accountant's level. Would you agree with me, sir, that net present value is essentially today's value of a future income stream?
Right, or future revenue and expense stream if you disaggregate it even further. Yes.
So put it a even simpler way, $1 I get today is worth more to me than $1 I get 20 years from now.
Yeah, that's generally the assumption.
Right? So if I understand your criticism of Plan B correctly, it's that Plan B has a lower NPV, net present value, than Plan A because of this $1.3 billion that is being front-loaded in Plan A to fund the credits. That's what's making the NPV lower, isn't it?
Actually, it's the other way around, meaning that the Plan B has a higher net present value cost to customers in comparison to the customer benefit.
But, and I was reversing it, but trying to get
You
to
did.
the same point, right?
The reversal makes a huge difference.
Fair enough. Let me
know.
rephrase the question.
Okay.
Because I'm the lawyer, you're the accountant, you're probably right on this. But Plan B, in your view, has a higher value,
higher cost to customers.
Because of the front loading of the $1.3 billion in Plan A.
Well, it's not.
There's more money up front in Plan A and less in Plan B. That's what gives it a higher cost.
It's all of the factors. Presumably, the $1.3 billion under Plan A is more beneficial to customers than a $1.1 billion credit over the 20-year period, simply because the dollar amount is greater in the upfront refund. But there are other components of the plan that there's give and take between Plan A and Plan B. When you take the net present value of the future stream of charges to customers over 20 years, Plan A, in our calculation, has a cost to customers net present value of $1.06 billion. And Plan B has a cost to customers of $1.203 billion. So Plan B is more expensive on a net present value basis when you take into account all of the components of each one of those plans.
All right, sir. And I know the bottom line is you don't like Plan A or Plan B, but
that's correct. Otherwise, it would be a false choice, essentially.
Right. And I guess what I was reading was you don't like Plan A because the money's up front and you got to pay it back later. You don't like Plan B because it doesn't have enough money up front.
Well, no, that's incorrect. The ORS has a plan that is based upon our analysis of the new nuclear development costs, Mr. Jones, and we have an analysis of what are appropriate regulatory liabilities, the largest of which is the Toshiba proceeds, and we have a plan for how to recover that over time. It has, on a net present value basis, although we don't like the upfront rate credit because it just simply has to be paid back, that's not what is the driving difference between ORS plan, the customer benefits plan, and the alternative customer benefits plan. Ultimately, it's the net present value of each of these plans and whether or not it provides appropriate rate recovery of the costs that the company is legitimately entitled to recover.
So with this, just final couple questions on this subject, Colin. Your criticism of Plan B is because of its net present value. I mean, is it your view that the customer, the 700,000 customers of SC and G, are more concerned about net present value than whether they're going to get a check for $1,000 or whether their rate's going to go down $20 a month?
You know, I don't know what customers are looking for in terms of upfront cash versus lower rates going forward. I mean, that's clearly a trade-off, but the way that you measure that, the value of each or the cost of each plan is to look at it on a net present value basis. And of course, it's a fair concern to look at the cost to customers on a residential bill basis as well. But you know, that trade-off there between upfront rate credits versus paying more in the future or just paying less in all years in the future to pay off the reasonable cost of the new nuclear development cost, that's a matter of judgment. But what should inform you, I believe, is which one costs less. given the dollar amounts that have to be recovered. And so if you agree with the ORS that the N&D cost should be less, then that's what should be reflected in the recovery. If you agree with the ORS that the rate of return should be less, that's what should be reflected in the recovery. And if you agree with the company that there should be upfront rate credits, well, you can do that as well. And then, as a modification, perhaps, to the optimal plan.
Those are all public policy decisions that are in the hands.
Very true. I mean, this decision-making process is clearly in your hands.
So, one last question. If Plan B, Dominion's Plan B, had an NPV, an equal to or better net present value than Plan A, would ORS then support it?
No. ORS support, and I mentioned before that would be, in my opinion, a false choice. You have two plans that are both inappropriate from our perspective, and then you say, well, one is less worse than the other one. No, they're both bad, and they provide for excessive rate recovery. So, you can modify a plan, and it can reduce the net present value, and you can do that, and you can get to the ORS optimal plan, which we again believe provides the appropriate, just and reasonable revenues to provide recovery of these N&D costs that are not disallowed.
All right, just a couple more subjects I wanted to cover with you, Mr. Collin. One is your assumptions and calculations with respect to savings that would result from the merger. All right, sir?
Okay.
And you've built into the ORS optimal rate a reduction in revenue associated with merger savings of $35 million in year one and $70 million going forward. Is that correct?
Yes. Through in the form of a rider. Yes.
$35 million year one, day one, year one, and $70 million in year two.
Correct.
Merger-related savings.
Yes.
Now, you understand that Dominion has said that we don't know exactly what those savings are going to be, and they're not going to happen right away. And so we will address that under the customer benefits plan and merger commitments in a general rate case in 2020 and build those savings into rates going forward in 2021. Do you understand that to be Dominion's position?
Well, I understand that those are the words that you've used to describe it, but essentially so I would say yes, that is Dominion's description of it, but let's distill this to the reality here. That means no merger savings for any customer unless and until South Carolina Electric and Gas files a rate case and base rates are reset, assuming that there are savings in the test year used for that purpose. And so, it really isn't part of the customer benefit plan. I think I would take a strong disagreement with that. It's going to be whatever it is under Dominion's proposal.
You wouldn't disagree with me, would you, Mr. Collin, that if the issue of cost of service, including any merger-related savings, is addressed in a general rate case, which will inevitably occur, that those savings would be passed on to customers long term?
Hypothetically, it seems like that would be true, but I presumably it would be true.
Fair enough.
Either through a pro forma adjustment or of some sort.
And do you understand as well that Dominion has said, and I think you would acknowledge this from your experience with other mergers, there is a cost to achieve these savings, right? That is a very real factor here.
Well, there is, and there are also savings at Dominion that will result due to this merger that will never see their way all the way down to South Carolina Electric and Gas. So I'm just saying this to point out the fact that Dominion has agreed that it will not charge customers for the costs of this transaction or the cost to actually transition SCANA and South Carolina Electric and Gas into the Dominion family of companies. And that's consistent with the FERC guidelines on mergers. that these costs don't get pushed down to the utility customers. And it's consistent. I mean, that's Dominion's commitment. And so I find it interesting that now Dominion is arguing that customers shouldn't get any of the savings in year 1 and 2 because, oh my gosh, we're going to achieve or incur some costs. And we don't know what those costs might be because Dominion refuses to quantify anything, and we don't know on whose books they will be or anything about them. So, I mean, having said that, I would agree with you that there are some costs that will be incurred to transition the companies, but again, Dominion has agreed to that it will not push those down onto the utility.
That's my point, and I know we want to move things along.
Sure.
It will be cost to achieve, and Dominion has committed that they will not be passed on.
That's right, and we have no idea what they are. We don't know if they're $5 million or $10 million or what they are.
Sure, and you know, it's Dominion's position that we don't know what they are right now because we don't own the company. And we're going to do this in a very planned, methodical way to figure out how to reduce the cost of service for customers. But we can't tell you what that's going to be on day one. You understand that to be Dominion's position?
Yeah, it's interesting. I'm glad you phrased it that way. That is Dominion's position, but I'll leave it at that.
You've come up with an estimate.
I have, because
I've
come up with an estimate based upon Dominion's actual experience in acquiring 2 gas distribution companies in the late 1990s.
That was 20 years ago, right?
Yeah, and I think that's not a relevant fact.
It's not a relevant fact as to whether Dominion's cost of service, its cost of centralized services may be very different and much leaner today than it was 20 years ago. That's not a relevant fact in your analysis?
I would say that the more relevant fact in my analysis would be the ability of Dominion to reduce costs at SCANA, because SCANA has a services company, so does Dominion, and to reduce costs due to best practices at the utility. And I will tell you that I've been around long enough to have been through a couple of dozen or more of these merger proceedings. And up until about 10 years ago, when a utility went to acquire another utility, it would come in with detailed cost estimates to do the transition, the combination of the utilities, and an estimate of the savings, and typically would offer to share those net savings, the cost minus the savings, and to share the net savings. But over the last 10 years, acquiring utility holding companies no longer do that. And they refuse to provide any estimates of savings, and then they argue, well, you can't incorporate any savings because, my gosh, nobody knows what they are up front. It's just kind of an interesting dilemma.
All right, sir, let me ask you a question that I hope you can answer precisely. You have testified that your estimate of the annual savings that will accrue as a result of this merger will be 33% or more based on your benchmarks, and I think that was from your direct testimony, page 61. Is that your estimate, 33% or more?
Yes.
In a reduction of O&M and A&G expense.
Yeah, but keep in mind that that was focused on the service part, not total O&M. And, you know, I assumed essentially in my analysis no savings whatsoever at the SCE and G directly incurred cost level. So no savings in linemen, for example, no savings in customer service reps, you know, that type of thing. But in the service company that provides centralized services, you know, the experience would be I applied a 33% factor. Even though with the 2 gas utilities that I used as my data, it was an all-in operating expense reduction. It wasn't just the service company reduction. It was total O&M, total A&G. So I really pared back what Dominion's actual experience was when it acquired these other 2 companies.
So when we talk about centralized services company employees, we're talking about things like IT, legal, investor relations.
That's right, accounting, human resources, those types of things.
And the idea is that being part of a larger parent that already provides those centralized services, there may be some synergies and ability to combine operations or reduce operations at the SCEG level that will result in savings. Fair enough?
Well, at the service company level.
At the service
you
company
said
level.
SCEG, but at the service company
SCEG
level.
services, right?
Yes. SCANA services, right?
So you also mentioned in your testimony, I think it was on direct testimony on page 79, that your understanding is that SCANA Services employs 1,751 individuals here in South Carolina. Is that your understanding?
Yes, I think I found that in the application in this.
Almost 2,000 services company employees here in South Carolina.
That's right.
And you have said, in addition to wanting to pass on merger savings to customers, that a priority of ORS is also to protect local employment, right?
That's right, and that can be done a number of different ways. For example, rather than gutting the SCANA Services company and just transferring all of the functions to Richmond, Virginia, some of those functions could be essentially transferred into South Carolina, and maintaining employment locally. But it's a fact of a fact of real world acquisitions and mergers. When you acquire another company, you cut costs, and a lot of those costs come in the form of employee reduction. And that's just a fact, and that's what Dominion does.
So that's what I wanted to ask you about. And there's folks in the room that have run businesses, and on the behind the bench that have run businesses. 33% reduction in costs sounds pretty significant to a lot of people, and particularly when you may be talking about headcount reductions. And is your fix here that you would take centralized services that are in Richmond serving Dominion's operations in 19 states, take those folks out of Richmond and bring them all down to South Carolina? Is that your fix?
Well, no. The fix is, first of all, this will happen, whether there's a merger savings rider or not. This is the way Dominion operates. It comes in, it assesses where it can save costs, and then there is, voluntary and involuntary terminations. And that's how Dominion achieves a significant savings in operation and maintenance expenses, and that will happen here. There's no guarantee under the customer benefit plan of local employment. If you read carefully, what they've offered to do is maintain their compensation for the existing employees. There's no commitment that there won't be voluntary or involuntary terminations. So,
Mr. Collin, let me interrupt you for a second. Dominion has committed to keeping the local headquarters for SCEG in Casey, right?
Right, that's true.
And it has made significant commitments to try to protect local employment, has it not?
Well, I don't think it has in terms of local employment. It simply has said we're going to keep the local headquarters in Casey, and we're going to maintain the compensation for the employees that remain, but that doesn't address the local employment issue. It doesn't address headcount. And because we know that this is how mergers are result in a significant reduction in headcount, my recommendation was that that Dominion maintain some of the functions here locally in Casey, and then also in order to retain some level of local employment, perhaps to transfer some of the centralized functions from Virginia here into South Carolina. I mean, it just seems to me an appropriate balance when you have such a large company acquiring another significant company, that you don't just gut the local company and then move all of the functions to Virginia. So that was the ORS interest, and we thought that was a balanced approach.
To be clear, and I'll close this out, ORS's recommendation is right away build in a 33% reduction in the cost of service at the services company level to rate. Would you agree with me, sir, that this commission should carefully consider such a proposal, balance that against the uncertainty of what those savings will actually be, and these other interests in preserving employment and preserving a local presence? I'm not asking you to change your position, but do you agree the commission should carefully weigh those considerations?
Well, I'm certain that it will. And I think that I have prepared a reasonable estimate based upon actual experience. And I think the commission can look to that and say, this is what Dominion has done and is capable of doing, and in my assessment likely will do, and to ensure that that some of those savings do go to customers before the next base rate case. That's all.
Next subject, this subject, levelization. You talked about in your testimony, pre-filed, and in your summary before the commission yesterday, and I think Mr. Elliott asked you some questions about this concept of levelization, where the cost recovery for N&D would be on a flat line or annuitized basis. Do you recall that testimony?
Yes, that is the ORS recommendation.
And generally, the cost of a rate-based asset would be recovered on a declining basis over time.
Right. It starts out high and then it declines as customers pay it off.
So this is a perhaps unconventional concept, not unprecedented, but not the way rate-based asset costs would be typically recovered.
Well, this is not unusual in where you have a fixed cost that needs to be recovered, and you want to do that in a fair manner and in a manner that affects customers the least. And in fact, the Dominion proposal, the Customer Benefit Plan, has that for the first 8 out of the 20 years, where they use their proposed refund of revised rates to essentially flatline the first 8 years of recovery, and then it goes back to the reducing or declining cost trajectory. And so, Dominion recognizes that this is recognizes that this is valuable and a good concept. And what the ORS has done is just levelize it over the entire 20 years rather than just the first 8 years.
All right. And you think levelization is something that the Commission should consider in this?
I do, because it reduces the impact on customers up front. And it's a guaranteed recovery over the 20-year period under the ORS plan at the same level. So it doesn't start out high and then decline in year 2 and decline again in year 3 and decline again in year 4.
So, Mr. Collin, I think this may be my last question to you. We have talked most of the morning, and I appreciate your indulgence on this, about risks associated with the ORS optimal plan, including the risk that this merger does not go forward, the risk of a legal challenge on appeal, financial risks to SC&G if the plan is adopted, the operational risks to SC&G if this plan is adopted. Do you agree with me that this Commission must ultimately decide if those risks are material and if they're worth it to adopt the ORS optimal plan from its perspective as the ultimate guardian of the interests of SC&G's customers and the utility and the state as a whole?
Are you asking for a yes or no answer? Yes. It sounds like a closing statement.
We haven't gotten a lot of yes or no answers, so yes, I am asking.
Okay. Well, generally, I would agree that there are risks under each of the plans, and you, as the decision makers, are going to have to assess those risks under each of the plans and do what needs to be done in terms of balancing the interests of recovery for the company on one hand and the impact on customers on the other hand.
All right, sir. Thank you very much, Mr. Collin. Thank you, Mr. Chairman. That's all the questions I have.
Thank you, Mr. Reed. Commissioners, Commissioner Elam.
Thank you, Mr. Chairman. Good afternoon.
Good afternoon.
And I may skip around a little bit because I find myself writing questions or issues on 4 or 5 different things. So if I'm not if the continuity is not there, I apologize. If we could work backwards, talking about the merger savings. And you used the examples of the gas companies. And I think counsel pointed out that those were some time ago. Do you have any examples of Dominion merging with an electric retail company?
I do not. Most recently, Dominion acquired Questar Gas in Utah, but that's a gas company.
What do you recommend if the merged company doesn't achieve your estimated savings?
Well, I think that the historical experience supports those estimated savings, and there's different ways to calculate them. And the difficult thing with merger savings is that they don't actually, the costs don't actually exist. They're not on anybody's accounting books. So they're costs that would have been incurred hypothetically, but for the merger. So what I think is a fair way to do it is look at what the costs were before and after, and then use that as the measurement of the merger savings. So I think that your question went to the uncertainty or the potential uncertainty of actually achieving savings, and so the measurement of those savings is very important. Because otherwise we're kind of just talking in an abstract way. But if the costs actually go down, there will be savings. If they are hypothetically not incurred, there will be savings. But I think that if there is a concern that the savings are not or were not or will not actually be achieved, then I would suggest a formula or a test, to assess whether or not there were actual savings. And
Do you have a formula? Do you have some information that the combined companies should have to provide so that you can make a judgment on that?
Well, I think that the companies have already committed that they will not pass through transition or integration costs. And so then the question becomes, since that won't be in the formula, if you accept that at face value, then the question is, are expenses actually lower in post-merger than they were pre-merger? So I would say maybe compare the first 12 months post-merger to the 12 months pre-merger and see if there was a reduction in expenses.
Are employee buyouts considered integration expenses?
They are, yes.
In your experience dealing with mergers, and when you're looking at merger savings, what portion of those are usually people jobs?
A very high proportion. Because there is significant redundancy, particularly at the service company level, and areas like accounting and human resources and legal. And I mean, that's a very sad thing from a human perspective, but that's how savings are achieved. And so usually there's severance pay, as you mentioned, and career assistance and things like that. But then people move on to other positions.
So you would expect, sounds like you would expect the majority of the 1,750 service company employees to not be working in South Carolina.
Well, I assumed a third, basically. A third of the actual charges right now from the service company, SCANA service company, to South Carolina Electric and Gas, the electric portion of that. I didn't assume any savings on the gas portion of the business, although there will be. And then if you assume that the bulk, I said a third of those costs that come from the service company to South Carolina Electric and Gas, then times 70% for the electric portion. And then I said, that would be something that would take a couple of years fully to implement.
Okay, so just roughly you would expect
maybe 500, 600.
A third of the employees to be gone.
Yes. And we have been, the ORS has asked significant discovery, and it has an ongoing obligation for the applicants to update estimates of savings or costs that will be incurred and things like that. And they're still at a position where they're telling the ORS that, listen, we don't have anything concrete. We haven't really developed any estimates.
Is that unusual to you that they would have no idea about merger savings before going into a merger?
I find that shocking. I would never buy a company if I didn't have an assessment of savings that I would be able to achieve.
some of these got answered along the way, and I'm just making sure.
Sure.
About securitization, are you aware of any legislation that is going to be introduced in South Carolina regarding securitization?
No.
Are you aware of any state legislation that you think is a good model for that?
Well, I think that in Florida there is a model to securitize storm costs, and I think that would provide a good model. In Texas, there is a model for securitization of stranded costs, which in essence this is. It's a stranded cost. So either of those two states' statutes would form, I think, an adequate and probably good statutory framework.
In your career where you have seen assets securitized, have you ever seen a legislature undo that bargain, that deal down the road?
No.
What percentage rate would you think would be set for securitization?
I estimated it between 4 and 5%. South Carolina Electric and Gas recently issued debt in the upper 3s, low 4s percents, and that was, I believe, at least one of the issues was unsecured.
Right. And you said essentially it's a governmental guarantee. What is it that the government, the state, have to guarantee to make that work?
Well, they have to guarantee that the rates will be sufficient to recover the debt that is issued by the special purpose entity. So in other words, it would be, once those rates are set, it would effectively be inviolate. And
I think I've heard you say in relation to the ORS optimal plan that the NND recovery over that period would be locked in for 20 years. Is that what you said?
yes, that's correct.
How would it lock in at that rate if a commission could come along later and change the rate?
Yeah. Well, that's a possibility, but I think that unless the utility comes in and seeks a modification to that rate, or some party brings a complaint to either reduce or increase it, that rate will stay in effect for that 20 years. And I think it's unlikely that the utility would come in and ask for an increase. I think it's equally unlikely that somebody would come in and ask, file a complaint to reduce that.
I think another witness in this proceeding has filed testimony that said this would work for Santee Cooper as well. You agree with that?
Securitization?
Right.
I think it would work for any entity. Now, I don't know the facts and circumstances with respect to Santee Cooper. I believe that it's probably very highly leveraged. In other words, most of its financing is debt, unlike South Carolina Electric and Gas, which has a combination of debt and equity. And got a little thing flying around here. I'm sorry, just not waving. And so the savings would not be as significant for Santee Cooper as they would be for South Carolina Electric and Gas of securitization. In other words, it would be an interest rate differential for Santee Cooper on debt, whereas with South Carolina Electric and Gas, it would be an overall rate of return, including the income taxes on the equity return compared to the securitization debt cost.
Okay.
And the make-whole payments, of course, on early retirements of the debt.
Okay. Going to the bankruptcy discussion you had, and you mentioned New Orleans utility. Is that the same as Cajun?
No, Cajun Electric Cooperative is in Louisiana, but Energy New Orleans is one of the operating utilities of Entergy Corporation. And New Orleans was destroyed in Hurricane Katrina, and including the entire electrical system in the city. It was very devastating. And I think that Energy New Orleans, it cost them over $1 billion in storm restoration costs. They had obligations to pay. under purchase power agreements to buy power that they couldn't deliver, and so they had to offload those purchase power commitments at a reduced price to third parties. And long and short of it was that Energy New Orleans filed, I believe it was a prepackaged bankruptcy, where they had agreement with their creditors as to how it would come out in the end.
Okay, with regard to those bankruptcies and others that you are familiar with, can you tell the commission what the result was for ratepayers' rates in the wake of those bankruptcies?
Yes, with respect to Cajun, Cajun was a generation and transmission cooperative that supplied power to member distribution cooperatives. And so after Cajun went bankrupt, then the distribution cooperatives entered into power supply agreements with third party. And 10 years, 20 years, or whatever. But my recollection is that those rates were less than what they paid to Cajun. And then with respect to Energy New Orleans, I believe that their rates were unchanged before bankruptcy, post-bankruptcy.
Unchanged?
Unchanged, yes.
How'd that happen?
Well, really, when you consider that there are some cost reductions in bankruptcy, including the automatic stay of interest and debt repayment, and the agreement that they wouldn't have to pay certain of the costs that they were obligated to pay under their purchase power agreements. The net result of all of that is that they came out of the bankruptcy in a financially secure position and did not need to increase rates. They didn't reduce rates, but they didn't need to increase.
One final thing, and I recognize that you've already said you thought this was a policy matter for the commission, but a little advice on policy. Upfront refunds versus applying funds to lowering rates going forward. Would refunds to customers more closely match making whole the people who paid the increased rates?
Well, I
those
think
two rates being lower going forward.
Yeah, I think that could be a consideration, but I would say this, that the money received from Toshiba is basically a refund of costs that were incurred by South Carolina Electric and Gas, and customers are going to pay those costs now over 20 years. So it just seems to me as a policy matter that you would want to match those two together, and
as opposed to
give the money up front.
The people who paid for the plant that are perhaps not on the system anymore and never got anything.
Well, under the customer benefit plan, there's a $575 million refund of amounts of revised rates that were collected. Under the ORS plan, there's a $400 million refund of those amounts. But I would view the Toshiba proceeds just a little bit differently in the sense that the allowed costs themselves, the principal amount, has not been paid by anybody. No customer has paid the principal amount of those N&D costs. All they've paid for through revised rates is a return on, a cost of money, basically. So, I just think that as a matter of policy, I would definitely lean toward netting the Toshiba proceeds against the N&D cost, and then have customers get that benefit over the life of the recovery. I can tell you what they did with Georgia Power. They gave some of the money back, even under construction. Georgia Power is building Vogtle 3 and 4. And what Georgia Power and the commission agreed to in the form of a settlement agreement was that part of the Toshiba proceeds would be given back to customers right now. I think maybe $75 million or $100 million or something like that. The rest of it was used to reduce their equivalent of the N&D costs. And so that will go back to customers then over the 60-year life of those two nuclear units.
So are you saying splitting the baby is a
Yeah, I
balance
mean,
there.
that's an alternative, yes, sure.
Couple more on the ORS optimal plan. You may have said this. What amount of capital cost impairment would the company be required to record?
Yeah, under the ORS plan, it would be 1.9 billion, and it would be 1.4 billion under the customer benefit plan. And keep in mind that that South Carolina Electric and Gas has already taken about almost 900 million of impairment losses.
You know the total amount that the company would be required to write off?
It varies by plan. I have it.
Or the optimal plan?
Yeah. I think it's 2.3 billion.
Okay.
Subject to check.
However we go about this, as your opinion on a policy matter, would you be in favor of putting this as a line item on customers' bills?
I don't really have any preference. I don't know if revised rates, for example, were a separate line item. And, maybe that would be a good guide. Or if the experimental rates were a separate line item on customer bills. I just don't know, but that could provide some guidance.
Okay. That's all I have, Mr. Chairman. Thank you.
Thank you, Commissioner Elam. Commissioner Howard.
Good afternoon, Mr. Collins.
Good afternoon.
Got a couple questions for you. Assume that the Commission approves ORS's optimal plan. Assume that Dominion walks. That leaves SCANA or SC&G as a standalone company. Considering all the changes that are coming about in the electric sector, there's going to be a need for access to the capital market. Do you agree with that?
Yeah, so there's always an ongoing need for access to the capital market.
I'm thinking about things like grid modernization, to allow renewables onto the grid, distributed generation, electric vehicles, advanced metering and all this, quite a bit of capital outlay. What did that leave? How did that leave SC&G approaching the capital market in the current position they are as a standalone company with their bond ratings?
Well, it doesn't foreclose access to the capital markets, and the stock price may go down, but it still will be publicly traded, and so SCANA will continue to be able to access the equity markets. And then the question on debt, even if you do not have an investment grade rating on your debt, you can still access the debt market. I don't personally have an investment grade rating. And in fact, I believe 95%, I think I read that someplace, 95% of the companies in the United States do not have investment grade debt. Utilities are really kind of like the very, very top quality of debt. But it doesn't preclude access to the credit markets or the capital markets, either for equity or debt.
But at what interest rate?
Well, as your rating goes down, there's an inverse relationship. The cost of debt tends to go up. But right now, it's a fairly narrow range. I think right now, what they call one click, one bond rating, is worth about 0.25% or 25 basis points.
Let me ask you a question I'm just curious about. Is the Toshiba money guaranteed? Do we definitely know that $1.1 billion will surface?
Yes, it's recorded on South Carolina Electric and Gas's accounting books as a regulatory liability. That means that it's owed to customers. It's recorded on their books. Now, what they've done is they've used that money, and rather than issuing other equity and debt. So in order then to refund it up front, somebody's got to get capital to do that, and that's what Dominion is offering with respect to the customer benefits plan. But if Dominion walks away, then South Carolina Electric and Gas and SCANA will be independent unless and until there's another suitor. And then SCE&G's proposal is that it will refund that $1.1 billion over the next 20 years. And that's consistent with the ORS plan.
Mr. Ziegler mentioned a weekly cash outflow, say, of $10 million a week or $500 million a year, offset that, you know what SC&G's cash inflow would be? You understand the question?
I do. I don't. There's a lot of different measurements of cash flow, but they boil down to what level of cash do you generate internally to meet your capital requirements. And most utilities do not generate enough cash internally to meet their capital requirements, so they have to get additional equity or get additional money through debt. And so, you know, I don't know what that gap is normally for South Carolina Electric and Gas, and I don't know what it will be going forward. But I suspect that there will need to be at least a couple $100 million each year access to the capital markets going forward.
Thank you very much. Appreciate your testimony.
You're welcome. Thank you.
Commissioner Hamilton.
Thank you, Mr. Chairman. Commissioner Howard and I undoubtedly had basically the same notes, but to carry it just a step or two further, if the optical plan was approved by this commission and SCANA and the merger would have failed, as we were pretty well told it would, how you think SCANA would have no problem raising the necessary capital to provide reliable services to the customers they serve in South Carolina?
That there will be a higher cost. There's no question about that, because it won't have the credit support from Dominion. But I don't believe there will be a problem in accessing the capital markets.
At lower rates and higher cost, you don't think this will push them into bankruptcy?
I don't, because going forward, at any time, if actually its revenues are not sufficient, it could come in and ask for a rate increase. But remember that all of the debt that is presently outstanding, that isn't going to change. That's not going to cost more or less. It costs whatever it costs right now, right? And it's only a down rating on debt may cost maybe 0.25% more or 0.5% more, but it's only on the new debt that is issued. So when you average it in, it has a relatively minimal effect. A real effect, but minimal.
Well, the cost of capital would increase substantially, wouldn't it, if it was available?
Well, it would go up if its credit metrics went down. That's the general rule. But it's first of all, it would be an issue of how much and what dollars of financing in the future would be borrowed at those rates. And I can tell you that in the debt portfolio right now that South Carolina Electric and Gas has, it's got a variety of interest rates, some higher, some lower. And we're still in a relatively low interest rate environment. And even if the debt costs 0.25% more or so, over time their debt costs still may go down as the higher cost issues in their portfolio of debt are retired and they mature and they pay them off. So it's not even necessarily a given that their debt cost goes up in the future, even if the next issue is more expensive.
You've discussed securitization. How valuable and how much could this help in a situation?
It could help it significantly. We estimate that it could save, out of the $86 million for the N&D cost recovery under the ORS Optimal Plan, it could save $35 to $50 million per year, depending upon the interest rate on that securitized debt and depending upon the make-whole payments that would have to be paid on the debt that is redeemed early.
Do you think it would be a valuable enough tool that someone should ask the legislature to consider?
I think so. It's so significant, and I think it would be beneficial to South Carolina Electric and Gas to just get this stuff off of their books.
Thank you very much. Thank you, Mr. Chairman.
Thank you, Commissioner Hamilton. Commissioner Whitfield.
Thank you, Mr. Chairman. Good afternoon, Mr. Collin.
Good afternoon.
I want to preface my first question with you with a little bit of a timeline. because I'm not exactly sure when you came on the scene, but you're aware that even back last year, even when I was chairman, these dockets were before this commission, and we were under statute to proceed and hear them within 6 months. And the oldest of these dockets even was Mr. Giles, that his petition that he filed even before the abandonment was announced. So we're going back a little while now. Now that the legislature has acted, and among other things, in the law, we couldn't start this case till November 1, have to rule by December 21, as we all know. But during that time, the Baker-Tilly and the Bates-Whites reports came out and addressed the impacts of the company of removing revised rates from revenues. In your analysis, and I'm talking about your support of the ORS optimal plan, in your analysis, did you consider the results of Baker-Tilly and the Bates-White reports in reaching your conclusion and your support for the optimal plan?
Not directly. I have read them, and there is some overlap, but it was not a direct factor in the ORS optimal plan. Generally, with respect to securitization, our analysis of securitization is that it would provide benefits, and significant benefits is consistent with Bates-White. With respect to the Baker-Tilly report and the effect of different levels of disallowances, we didn't really directly incorporate that because our plan was based upon the allowed. It wasn't a hypothetical. It was what we recommended that you allow for cost recovery. And then whatever disallowance was fell out of that, basically.
And down the line of your support, or ORS's support for the ORS optimal plan, and I believe I'm pretty clear on your position, but just for the record again, would the company be financially viable if the commission adopted the ORS optimal plan and the merger with Dominion did not take place?
I think that the credit metrics, because there would be additional impairment write-offs and it would reduce common equity, they would experience a deterioration of credit metrics from today's level, but going forward they would rebuild that, and I believe they would succeed on their own through additional equity infusions from SCANA. And SCANA can access the equity and the debt markets to make those additional equity infusions.
But until that credit metrics is repaired, I guess is the word you used, or improved.
Restored, yeah.
Restored, improved, the cost of borrowing, cost of debt, at least in the short term, and I'm going to borrow Commissioner Hamilton's word, would be significantly higher. Or do you disagree with that?
I don't know if it would be significantly higher. It could be 0.25% more. Remember that just in August, with all of this hanging over South Carolina Electric and Gas, they issued 2 tranches of debt, and ranging from the upper 3s to the lower 4s. That's still remarkably good interest rate on longer-term debt, 10 to 30-year debt.
Well, you've certainly answered my question about what you think about the company being viable, but I do want to go a step further because, and you've also said to Mr. Reed, I think you've made comments along those lines when Mr. Reed was crossing you, but yesterday you said that that you thought if the company did go into bankruptcy, that you thought a bankruptcy judge could or would allow the commission to, under its powers here vested in it, to continue to fix and set rates. And if you, I guess, stand by that statement you made yesterday, what would that be like working with a trustee if we have a debtor in possession? I do come from a business background, and my background and experience with bankruptcies, while limited, was not good.
Yeah.
So I would like to get your opinion on, since you made that statement yesterday, how you envision that might be.
I can tell you how it worked in Louisiana with respect to the Cajun bankruptcy. And in that case, there was a challenge as to the authority of the commission to continue setting rates while Cajun was in a bankruptcy. In Louisiana, the Public Service Commission has jurisdiction over rate making for cooperatives as well as investor-owned utilities. And the Fifth Circuit came down unequivocally and said, hey, bankruptcy court does not take over rate making from a Public Service Commission. So I know that because I lived through it. Then what we did was, on behalf of the Public Service Commission, is there were bids for Cajun's assets, and then there were separate bids for suppliers to the distribution cooperatives with long-term rate paths, 10 years. And then we assisted the commission in figuring out what were the best rate paths. Then all of that information was incorporated into a reorganization plan before the bankruptcy court, and ultimately it was approved. I mean, this was not a painless process, but it took a couple of years. But it was resolved, and was resolved well, I think.
Now that you brought up Louisiana again, let's talk about that just a minute. Let me get this straight in my mind. Cajun serves some cooperatives that are not for profit, not investor owned, correct?
That's right, yes. And most of Cajun's debt was with the Rural Utility Services, the federal government, or agencies of the federal government, right, like the Federal Financing Bank, CoBank.
And my knowledge of the Louisiana Commission is correct. They do regulate some entities that we don't, but if I'm not mistaken, the city of New Orleans has jurisdiction just in the city, just like we do here in South Carolina. We don't have jurisdiction over municipalities. So some of those areas were served in the hardest hit area of New Orleans. Are we talking about cooperatives that were not related to the muni service that would be under the jurisdiction of the city? Because they do have a separate commission there in Louisiana. I guess you're aware of that too.
Yes, and Energy New Orleans is an operating utility of Entergy Corporation, and they serve the city of New Orleans. It's an investor-owned utility. And the city of New Orleans has jurisdiction over the rates charged by Entergy New Orleans within the city limits.
And I'm familiar with Entergy too, and you might remember there was some debate after Katrina back at NARUC during those times about federal aid, and the debate was to the public power, if you will, the co-ops and munis, the not-for-profit, non-investor-owned, versus aid to an Entergy that is an investor-owned. And the comment was, you're using taxpayer money to possibly help an IOU, an investor-owned utility. But in that scenario, there were no ratepayers left in a lot of the investor-owned utilities companies' service territory. And in other words, you had not only were your assets gone, but your ratepayers were gone because they had to relocate from the severe damage that occurred there.
Right. Those factors...
And it took years to get them back in there.
It did. There was a natural disaster, of unbelievable proportions, and it took a number of years. And Energy New Orleans had these purchase power agreements. It had other costs that weren't being recovered any longer by customers' revenues because people had lost their homes, they lost their businesses, and things like that. That's really not the situation here.
Exactly. That's what I'm saying. We're talking about two entirely different scenarios, a natural disaster versus this situation.
And I think in that situation, Energy New Orleans didn't have any choice about filing bankruptcy. It was just crushed with debt. And I think it's a far different situation here. I don't think bankruptcy is a realistic likelihood.
One more example of bankruptcy while we're still on that subject, and I'll move on. Since this is your field, are you familiar with the PG&E bankruptcy? And if you are, could you tell us your knowledge of how that turned out?
Yeah, I know that they did declare bankruptcy, but I don't know any details about it.
Do you know how many years it took them to overcome and what the cost was to ratepayers in that case? Do you have any knowledge of that?
I don't know.
Okay. Let's move on. The letter that was presented by Mr. Reed by Speaker Lucas. I'm not going to go down the viability of the company or the bankruptcy path, but what about Speaker Lucas's concern of SCANA being successful on appeal? What